Okay, so today we are going to do the Registration Act 1908. First of all, when did it come into force? 1st January 1909. Right? 1st January 1909. How many? There are no chapters in this, there are parts, and there are 15 parts in this. So 15 parts came into effect on 1st January 1909. Okay, now registration, when does this process come? First of all, you draft a contract or any of the documents. There is a draft, then you execute it. Execute means that you sign it, right? After that, it is attestation means that when the witness is signing, and when the witness is seeing the executant sign, and then he is signing, so that is attestation. And then post attestation, it is registration of the document before the government. Okay, now we come to the definition clause, section number 2. Section number 2 means there are quite many important definition. First of all, we have district court. Now in this case, district court also includes a high court in its ordinary original civil jurisdiction. So it also includes high court, so this becomes very important for the pre. Otherwise, district court does not include high court. Okay, then we have addition, book is not important, district 2 subsection 4. Then we 6 and 9, 69. 6 is immovable property, 9 is movable property. Immovable property includes your land, buildings. Hereditary allowance is important, fisheries is important, which can create confusion. So hereditary allowance, fisheries, it does not include SGG. SGG means standing timber, growing crops, grass. Okay, then we have 9 says movable property. So movable property obviously includes SGG. It also includes your fruit. It also includes the juice in trees. Okay, and except immovable property. Okay, then we have 7 is lease. Lease includes your counterparts, then kabuliyat, then undertaking. Okay, so lease includes a counterpart, kabuliyat, and an undertaking to cultivate or occupy, and an agreement to lease. 4 things: counterpart, kabuliyat, undertaking, and an agreement to lease. So even if it is signed by one party, registration is required, right? Because kabuliyat and counterparts are signed by one party. Okay, rent note, etc. Then we have part number 2, from section number 3 onwards. Section number 3 talks about Inspector General of Registration. So state government shall appoint one Inspector General for registration. Okay, and Inspector General may hold simultaneously any other office under the government also. So he would not be restricted to holding just this office, or he would not exclusively be holding this office. He could, or he may simultaneously hold any other office as well. Okay, then we have section number 6, registrars and sub-registrars. Ticket registrars and sub-registrars can be public officers or not. It will also be appointed by the state government. They might be public officers or not. Registrar would be there for a district, and sub-registrars would be there for districts, and as I said, sub-registrars would be there for subdivisions. Okay, then office of registrar and sub-registrar. Okay, so sub-registrar may also perform duties of the registrar. That is also the sub-registrar can also perform duties of the registrar, but in no case he shall hear the appeal which he has against an order which he himself has passed while acting as registrar. So he can act as a registrar, he can perform the duties as a registrar, but he will not hear the appeals which he himself has passed while acting as sub-registrar. Okay, now he was acting as sub-registrar, he passed an order. Okay, the person went on to appeal to the registrar. Now he is acting as registrar, so he cannot hear that appeal. Okay, that is section number 7. Section number 10 is also important for the prelims perspective, that if the office of the registrar is temporarily vacant, okay, and first of all, who can take charge of that office? Any person whom the Inspector General appoints in this behalf, or even the district judge, or even the judge of a district court. Now, as we read, the district court also includes high court in its ordinary original civil jurisdiction. So even a judge of the high court can become a registrar in this case. Okay, so judge of a district court, 1, and 2, any other officer that Inspector General may appoint in this behalf. Okay, if the office of the registrar is temporarily vacant. Now if it is like he is absent, so sub registrar can perform his duty for 1 or 2 days. Okay, now State government needs to be given a report by the Inspector General of any of the appointments that are done in 10, 11, right, and 12. So 10 would be that you're appointing a judge in that respect, or you're appointing any other person, or you're appointing sub-registrar as a registrar. So all of that information needs to be sent to the state government, and who is the person in charge who will do that? That would be the Inspector General, okay, under section 30. So right now our important sections are of appointment. Section number 3 appoints Inspector General, section number 6 appoints registrar and sub-registrar, and section number 8 appoints inspector of registration. So there would be an inspector of registration of officers as well. Okay, so 3, 6 and 8 are important. Okay, then 10 absence हो गया, उसके बाद अब 13 में वो हो गया. Now come to section number 16. Section number 16 says register books and fireproof boxes. So the state government shall provide for the offices registering office of the books, जिसका जो भी format या performa होएगा that shall be sanctioned by the or prescribed by the Inspector General. कि आप उसमें कैसे कैसे आप डेटा मेंटेन करेंगे, where what will be find serial number, name of the parties, phone number, all of that thing, entire format of that shall be prescribed by the Inspector General, and that book shall be given by the state government. And the state government shall also provide fireproof boxes to the office of every registrar, and tell them shall also make provision for safe custody of the records. Okay, 16a talks about e-form, so keeping the books in computer floppies and diskettes hai, and this was inserted in 2001. So remember 2001 में insert हुआ था, right? So may also be gathered, so the data may also be stored in computer floppies or diskettes. So these are two alternatives that are available to the registrar. Okay, then we come to the most important section of this entire act, is section number 17. Section number 17 talks about compulsorily registrable documents. Section number 18 talks about registration of documents which are optional. Now which all the documents need to be compulsory registered? Compulsory registered, first of all, gift. ठीक है, okay, so gift has to be compulsory registered. Then non-testamentary documents need to be compulsory registered. Types of non-testamentary documents which need to be compulsory registered, we'll be discussing. Non-testamentary documents, testament means a will, so non-testamentary are all those documents other than will, right? So non-testamentary documents which are creating, assigning, diminishing, limiting, which are creating, assigning, declaring, limiting and extinguishing, ठीक है, any of the right of the present and future, any right, title, interest in the property of more than 100 rupees, ठीक है. So basically non-testamentary instrument of more than 100 rupees हो गया. Non-testamentary instrument which acknowledge the receipt, so acknowledge the receipt हो गया, ठीक है. Then leases of immovable, lease हो गया, lease of immovable property for year and year rent, या फिर for year to year term exceeding 1 year, या फिर which has reserved an yearly rent, कि आप yearly में एक साल में एक बार ही rent दोगे, ठीक है. Then we have क्या कहते हैं, नॉन टेस्टिमेंट्री इंस्ट्रूमेंट्स, ट्रांसफरिंग और असाइनिंग एनी डिक्री और ऑर्डर ऑफ द कोर्ट और एन अवार्ड, ठीक है. एग्जेम्प्टिंग, जिनका जो रेंट है, एनुअल रेंट, इट डज नॉट एक्सीड 50 रुपीज़ और द लीज डज नॉट एक्सटेंड 5 years. ओके, सो दैट इज देयर. देन पार्ट परफॉर्मेंस, जो कि आपका 53A में आता है इन ट्रांसफर ऑफ प्रॉपर्टी एक्ट. द पार्ट परफॉर्मेंस दैट नीड्स टू बी कंपल्सरी रजिस्टर्ड. इफ इट इज नॉट रजिस्टर्ड इट शैल हैव नो इफेक्ट. Okay, now subsection 2 talks about exceptions. Okay, so nothing in clause B and C of subsection 1 shall apply to composition deed, share and debentures. Okay, any document which is merely creating a right to obtain another document, just say right, for example your agreement to sale, so it is not by itself, it is not creating or assigning any right, but it is creating a right to obtain other document. It does not need to be compulsory registered, right? Composition deed, shares and debenture, then any kind of compromise deed, any kind of grant of immovable property by the government, okay, and any instrument of partition which is made by the revenue officer. Remember, the word here is revenue officer and not civil code. So any instrument of partition which is made by the revenue officer, okay, any kind of mortgage deed. Okay, so registration is only done when entire mortgage has been redeemed and not on partial payments. So partial payments में आप registration नहीं कराते हो. Once the entire mortgage has been redeemed, then you can get it registered. Okay, and authorities to adopt a son need not be registered. Okay, I think I mistakenly said that authorities to adopt a son need not be registered, but it on the contrary, it is that authorities to adopt a son shall also be registered, because this comes under subsection 3. So authorities to adopt a son is not the same as adoption deed. Okay, then we have section number 18. Section number 18 talks about documents of which registration is optional. First of all, the most important is will, right? Then any other document miscellaneous which is not covered by section 17, for example your adoption deed. Okay. Third, any immovable property the value of which is less than 100 rupees, right? Any acknowledgement of receipt the value which is less than 100 rupees. Okay. Any instrument which is transferring or assigning any decree of the court the value of which is less than 100 rupees. Okay. And leases of immovable property which are not for year to year basis, right? So those are there. Okay. Then section number 19 talks about the power to refuse registration by the registrar if the language is not understood by the officer. If the language of the document is not understood by the registering officer, he shall refuse to register the document. Okay, unless and until a true translation has been given. Similarly, if there are any blanks or if there are any interrelation or alterations to be done there, then he shall also refuse to accept the document. Okay, that is in 20. Then along with the document you need to also give the description of the property, the map of the property, the plan of the street view. Only then when all the documents and the annexures are complete, the registering officer will register the document. In the failure of it, it shall not register it. Okay, so get it? So unless it has to have a description as to where this property is situated and what is the description of the property. Okay, then 22 means that if the description of the map is not available and there's a government map, so government map will be sufficient. Okay, and it shall also, there's an exception also, given that the description of the property to which it relates is sufficient to identity, right? It's sufficient to identify the property, then the registering officer will register the property. Okay, then we come to section number 23 part 4. 23 part 4. Part 4 talks about time of presentation, when the document needs to be presented. Okay, right? First of all, will can be presented anytime, that is given under section number 27. Will can be presented anytime. Now section number 23 says that any document other than will may be presented within 4 months. अब इसमें आप number 4 याद रखेंगे. Everything here is within 4 months. So within 4 months of the execution, the document shall be presented. Okay, if it's a क्या कहते हैं copy of a decree or a order, again within 4 months of it being final. Okay, if a document needs to be re-registered because the earlier registration was by a person who was not duly empowered to register the document, same again within 4 months from being aware of that registration of such document is invalid, right? And it shall be deemed, again it will be relating back procedure, it shall be redeemed from the date of its original registration. So Registration Act में relating back has an important role to play. In section 23A and other on, we will also see that the registration becomes valid not from the date of it being registered but from the date of it being executed. The doctrine of relating back, it also works in section number 23. Then we have section number 24, that it is document is executed by several persons at different times. So the document is executed by by 4 people. One executed in January, then 4 months will begin from January, Feb, March, April, right? The other one executed in March, so again the 4 months will begin from March onwards, so on and so forth. So within 4 months from date of each execution, it can be registered. Okay, now where delay in presentation is unavoidable, if the delay in presentation is unavoidable, so the government gives you another 4 months provided you have to pay the fine. Okay, with fine does not exceed 10 times of the amount of registration fee. Okay, so after paying that fine, the government within those 4 months, ऐसा नहीं that you can come in and any time and pay that fine and get your property registered. No, so within 4 months from execution, if you're not able to get it registered within 4 months, then government will give you next again 4 months, but that 4 months will be subject to you paying the fine, and the fine will not exceed 10 times of the registration fee. Okay, then we have documents executed out of India. If the document executed out of India right? Then it can be presented for registration within 4 months after its arrival in India. When the document is executed out of India, then within 4 months after its arrival in India. Okay. Okay, the application will be made to the sub-registrar, but it shall be decided by the registrar regarding the fine. Okay, so regarding the fine, application will be made to the sub-registrars, but it shall be decided by the registrar. Okay, then I told you about section number 27. Section number 27 talks about will. Then 28 is part 5. Part 5 talks about place of registration. Okay, so place of registration in cases of immovable property would be where the property is situated or any part of the property is situated. Okay, and place of registering any other documents like the decree or the order of the court or any other documents. Okay, then the sub district of where the document was executed or at the desire of the executed. It can be at the desire or where the document was executed. Okay, then a copy of decree or the order of the court, again where the decree was made or it does not affect the immovable property, then at the desire of the executant. Okay, then we have 31, registration for deposit at private residence. That means the registrar can also go at the house of the person if there any kind of special cause, and then the person can deposit the will at his convenience. Okay, in ordinary cases the people have to go to the registration officer, but if there's a special case or a special cause being shown, so registering officer can go to the attend at the residence of any person desiring to present such document for registration or to deposit a will. In any of those things, in any of both the things, he can go at the place of the person, right? Then we come to part 6. Part 6, section number 32 onwards, of presenting documents for registration. Okay, now the 32 says that every document to be registered in this act, whether such registration be compulsory, options. Okay, so the documents, persons who okay, section 32 talks about a person who need to be there in order to execute or register the document. Okay, so the beneficiary, by some person who's executing or claiming. Okay, by the representative or assignee, for example karta, by the agent or power of attorney. All of these people can take the documents for registration. Okay, the beneficiary, the person who's claiming under the same or executing, the representative or the assignee, or the agent, or or somebody who's duly authorized by the power of attorney or duly authorized power of attorney. Okay, then I think is important here. Then we come to section number 34, inquiry before registration of registering by registering officer. So registering officer can also conduct inquiry in order to see that whether the documents was executed by the person whom it purports to be have been executed, what is the identity of the person, satisfy himself as to the identity of the people. Okay, and satisfy that the person who are appearing are the real or legit representative of that person. Okay, so he is not a mere spectator, he has all the power to do an inquiry before registering. Okay, and nothing in this section applies to decree or order. This is important because decree or order is any which way is given by the courts. In that case, registering officer does not need to do an inquiry. Okay, and if he does an inquiry and he cannot seem to give any conflicting views as to the findings of the court. Okay, then we have 35 that all the persons executing the document will appear personally before the registering officers, right, and they all will admit to the execution of the document, and if they admit, the registering officer shall register. Okay, and if the person in any case document proposed to be denies its execution, or if the person is minor, or if the person is lunatic, the registering officer shall refuse to register the document. Okay, and then we have part 7. It begins from section number 36. If you've realized, section number 23, right, was part 4. It was a section number 23, but it was part 4, right? Similarly, it is section number 36, but it is part 7. Okay, so that is there. Now 36 talks about procedure where appearance of executant or witness is desired. Okay, so if any person desires the appearance of any other person, he may apply to the registering officer, and registering officer may in his discretion summon and require him to come to the office. Okay. Then 37 says officer or court to issue and cause service of summons. So who can service the summon? Either the RO or the court. Both of them can service the summons. Okay. Then 38 says person who are exempted from appearance at registration officer. One, bodily infirmity is unable to come. Take a person who's in jail, a person who's exempted by law. All of these are exempted from appearance at the registration officer. Okay. Then in case of every such person, the RO shall either himself go to the house of such person and examine him, or issue a commission for his examination. He can also issue a commission for his examination. Okay, either he can go himself or he can also issue a commission. So वो घर पे भी जा सकता है, वो इनका एग्जामिन करने भी जा सकता है. Okay, then we have the next important is part 8. Now part 8 talks about will, which is very important. 8 talks about will and it starts at section number 40. Now will has 4 alphabets, so it starts with section number 40 and into to part 8. Okay, that's how you can remember it. Now 40 says persons who are entitled to present will and authorities to adopt. Okay, so the testator entitled to present wills and authorities to adopt. So first of all, will can also be registered after the death of the testator. Testator means the person who is making the will. Okay, so will can also be registered post the death also by any person who's claiming as an executor. Okay, so after the death of the testator, it can be registered by the executor. Similarly, authority to adopt would ordinarily be registered by a donor, but after the death it can also be registered by a donee or the adoptive son. Okay, that is section number 42 as to who may register the will or the authorities to adopt. Okay, second, registration of wills and authorities to adopt. Okay, so by any other person से तो हो जाएगी testator donor की मेरी will है मैं दे रही हूँ. Now if it is by another person, so it is the duty of the RO to satisfy that actually it is done by the executor or the donee. Okay, first thing. Secondly, that the will is actually of the testator and the donor. Okay, the will is actually of the testator and the donor, and the person who are presenting the will have the authority. So it can be presented by the person who has the power of attorney also. It can be presented by any of the other beneficiaries as well. So that person also has the authority to do so. Okay, then we have part 9. Part 9 is of deposit of wills. Part 9 starts with section number 42. Section number 41 में रजिस्टर होती है wills. Okay, याद रखना 40 में आपको पता है कौन रजिस्टर करेगा, 41 में wills रजिस्टर होती है. Okay, 42 पे बोलते हैं that testator, okay, any testator may deposit with any registrar his will in a sealed cover. So testator जो है वो deposit कर देगा registrar के पास his will in a sealed cover with his name on it and all the other procedure on it and with the statement as to the nature of the document. This is the will and this is my will with the name of the testator. Okay, then जो procedure on deposit of wills है. Okay, so on receiving such cover the registrar if satisfied that the person presenting the same is the same, जो अपने 41 में अपने आप को satisfy कर लेता है कि वो उसका agent है, वो transcribe कर देगा और book number 5 में उसको रख देगा. ठीक है, and उसमें लिख देगा and in the register it will write the year, month, date, time, hour of such presentation and उसको receipt दे देगा. Okay, and then उसके बाद this will be moved to a fireproof box. Now when now testator can withdraw this will at any time. He will pay a nominal fine and can withdraw this will at any time. Otherwise, after the death of the testator, the executor or the beneficiary of the will come and say proof that the person has died. तो उसकी will उसके सामने खोलेगा. ठीक है, ओरिजिनल अपने पास रखेगा, उनको कॉपी देगा पार्टीज को. ओके, सो दिस इज द प्रोसीजर. ठीक है, सो इफ द टेस्टेटर विशेस टू विड्रॉ, रजिस्ट्रार कर देगा एंड शैल डिलीवर द कवर अकॉर्डिंगली. नाउ डेथ ऑफ द टेस्टेटर में द रजिस्ट्रार शैल रीडिपॉजिट द ओरिजिनल विल एंड कॉपी शैल बी गिवन टू द पीपल. ओके, डन. उसके बाद आता है 47. 47 also as I was talking about its doctrine of relating back. So 47 and 23A. 47 आपको याद रखना पड़ेगा, राइट. ठीक है, this is like relating back का है 47. Okay, so a registered document shall operate from time which required commenced if no register therefore had been required and not from the time of registration. Okay, so that means from the time of execution. Okay, simple sentence, from the time of execution. Okay, then 49 talks about effects of non-registration. The effects of non-registration is that it shall not be received in evidence. Okay, it shall not confer any power to adopt. Then it shall not affect any rights of any immovable property which is comprised therein. Very simple, right? But unless it has been registered. Okay, but it can be still used as a contract. Okay, not affecting the rights of the immovable property, but as the evidence that there was a contract, or of any other collateral transaction. Okay, which is independent, or either it is independent or it is divisible from the transaction which requires registration. Okay, so that would be 49. Then we have 51. 51 talks about the books. Okay, so 51, book number 1. Book number 1 denotes for T. So book number 1 is for register of non-testamentary documents. Okay, book number 2 denotes N. So N means no. So refusal, reasons for refusal to register would be in book number 2. ठीक है, then book number 3 stands for M को अगर उल्टा करें W, book number 3 relates to will. ठीक है, register of wills and authorities to adopt. Okay, and book number 5 is deposit of wills. 3 and 5 are odd numbers, तो उसमें deposit of will आ जाएगा. Book number 4 is R, तो it's a normal register, it's a miscellaneous register. That's how you will remember all the books. ये आ सकता है आपके prelims में. Okay, 51 में books दे रखे हैं. Then 57 है that the RO to allow inspection of certain books and to give certified copies. Okay, so जो subject to the payment of fee, आप इसमें nominal fee दोगे, and जो book number 1 and 2 है वो जितने all persons or whoever is applying for it, उसको आप you will give that book to inspection to that person. ठीक है, book number 1 and 2. Book number 1 is non-testamentary documents का register. For example, if you want to know in whose name this property is, you can go to the registrar, you can see that in whose name this property is, in order to see whether the property, the person who's selling the property or the owner who's selling you the property is genuine or not, right? So book number 1 is that. Book number 2 is the record for refusal to register, or why this property has not been registered, so on and so forth. Okay, the access of book number 3 is given to the persons who are executing the documents, right? Because it is a will, it is a personal matter, the authority to adopt, it's a personal matter, so it is only given to the person who are executing the documents. Okay, and after the death of thus executing, to any person who's applying for such copies, and after the death to any person. Okay, book 4, any, again the person executing, right? Okay, then we have certificate of registration. Certificate of registration shall be given. Okay, and endorsements and certificate of registration is just important for section number. It is section number 60. Okay, then we have endorsements and certificates to be copied and documents need to be returned. Okay, then let me just check. Power to administer oath. RO has the power to administer oath. That's also one liner that is important. Okay, and if it the document relates to land in several districts, right, so the registrar shall give it to other districts also, where the document relates that this property has been registered, or this property, right, has been registered. And if it relates to sub districts, so again to sub registrars ko you will give the intimation. Okay, then we have 69 में power है inspector general, then we have registering officers, then we have sub registrars, right? So inspector general has the power to make rules. So किसके regarding make rules करेगा? एक तो I told you that he will see the format, दूसरा safe custody of books, then तीसरा what will be the common language, right? Then what would be the amount of fine that would be there, and inspector general also has the power to remit fines in section number 70. तो जो भी आपके 10 times fine लगे हैं for non registering within the time, वो inspector general remit कर सकते हैं. Then part 12 में है refusal to register. अब उसकी अपील कहाँ जाएगी? फर्स्ट ऑफ ऑल, अगर आपने रिफ्यूज़ करा है रजिस्टर करने को, तो यू विल रिकॉर्ड योर रीजंस इन राइटिंग. ठीक है, सो अपील जाएगी विद इन 30 days. ठीक है, सब रजिस्ट्रार से रजिस्ट्रार के पास अपील जाएगी विद इन 30 days, राइट? और अगर दिस इज अपील इज इन द केस वेयर इट इज ग्राउंड अदर दैन डिनायल ऑफ एग्जीक्यूशन, राइट? बट इफ द ग्राउंड इज डिनायल ऑफ एग्जीक्यूशन, देन अपील नहीं जाती है, एप्लीकेशन जाती है रजिस्ट्रार को विद इन 30 days. ओके, it's a terminology that's different. अगर the ground is other than execution, so appeal जाएगी to the registrar within 30 days, and if the ground is denial of execution, then application जाएगी to the registrar within 30 days. Okay, then we have, there is no second appeal, so there will be no appeal from the any order of the registrar. Okay, but you have a right to file a suit, so you can file a civil suit under section 77 again within 30 days, right? Within 30 days you can do it. And इसमें penalty, इसमें दो offenses हैं, उसकी penalty इसमें दे रखी है, imprisonment of 7 years or with fine or both. तो फर्स्ट है for incorrectly endorsing, copying, translating or registering documents with the intent to injure. अगर है तो imprisonment up to 7 years. 81 में, 82 में है for making false statements, delivering false copies or translation of false personation, against 7 years with fine or with both. ठीक है. Then registering officer may commence prosecution but with the permission of the inspector general. So अगर जो offences हैं जो दे रखे हैं, prosecution for any offence will be commenced with the permission of the inspector general, and it shall be triable by any court not less than that of JMSC. SC मतलब second class लिखा हुआ, not less than JMSC. Okay, and the registering officer होंगे, they shall deem to be public servants under this act. Okay, then we have registration of documents if it is executed by government officers or public functionaries. Okay, they are not required to appear in person if they have executed a certain document in their official capacities. Now who are those people? Any officer of the government, the registrar of the high court, ठीक है, the sheriff or receiver of the high court, ठीक है, the administrator general, the official trustee or the official assignee, or any other person who is the holder for the time being of such public office and who has registered in his official capacity. That is it. I think that is it for now. Thank you so much. We'll be back with another act.